Recall there was a worker called Bao last year in December. He was charged in court under the Criminal Law Temporary Provisions Code, and he was accused of actively participating in the strike, and also for being rude to the SMRT management when they convened a meeting to talk about their concerns. So when we went to China to interview Bao Fengshan, he was clearly still quite distressed and quite upset about what had happened. And he said that after the meeting at SMRT, police officers came to bring him to the police station to sign statements and to say that he would be charged in court for participating in the strike. And throughout that entire process, he said that when he was being charged, he didn't know what to do. He was very confused. When he asked his Chinese embassy about getting a lawyer, they told him that if he wants to engage one, he would probably have to pay a lot of money, and that the embassy would not be able to help. And so because of that, he said, well, I feel I don't have much of a choice, so I might as well just plead guilty, and just admit to whatever charges that they are leveling against me. So I bring up Bao Fengshan's case specifically because it has broad implications in terms of issues of access to justice for migrant workers. When Bao was charged in court, the senior district judge who presided over his case said that his involvement was calculated to cause disruption and inconvenience to transport services. But Bao Fengshan was not among the four who were eventually charged and convicted, also who had planned and talked about the strike action. So according to him, when we interviewed him in China, he said that he was merely a participant. And he also refutes that he made those threatening comments to the SMRT management. And even so, this also has its own bearing whether he participated in the strike or not. So, however, because he was unable to afford a lawyer, he felt that there was little he could do to prove his case in court. And migrant workers are actually eligible for the Law Society's Criminal Legal Aid Scheme. However, this scheme does not provide assistance to those who are charged under, say, the Criminal Law Temporary Provisions Act, and also a whole host of other offences like the Employment of Foreign Manpower Act. So, similarly, last year, 29 SMRT drivers were also deported, and their work passes were revoked without, in my view, respect for due process. So we also interviewed these workers in depth, those who were deported, and I'll read some extracts based on the interview that we had with them. Okay, this is what one of them had to say. They first revoked our work permits and got us to sign some documents. Then we were told we had violated some rules and laws and would be repatriated. The officer at the prison mentioned that they understood that we were feeling unhappy. But the whole thing has already been decided, and there is nothing much we can do. Then the representative from the Chinese embassy showed up. We felt it was unnecessary for them to come, because nothing was going to change. At 1 a.m. we went to the airport, and at 6 a.m. we arrived in China. I stood up.
The video's ready.
Huh?
The video's okay.
Video's ready. Okay, I'll show it at the last bit.
Okay. Now it's the mic. Okay.
Now it's the mic. Huh?
Just talk louder.
Just speak louder.
Hello, hello. Okay. Okay, I continue what this worker said. I stood up and asked what offense I had committed and why I was asked to leave. The officer said that it was due to the strike. I said it was not a strike. It was to defend our rights. The officer smiled. He told us this was not up to him. It was a decision from management. There was no room for reasoning. He was just going through the process. We then dealt with our bank accounts, immigration, and other government agencies, and finally my work pass was cancelled. Then we were taken to another room. After my work pass was cancelled, I felt like another person. I was no longer a respectable bus driver, but a prisoner. Maybe the way the police treated us as we moved from room to room made me feel that way. At the first room, I did my medical check, and in the next room, I was asked to take a shower. I told them I showered before coming. They were very forceful and forced me to shower. After that, our civilian clothes were taken and sealed in a big bag. We were given prison uniforms to change into. The shirt and pants were way too big for me. Then we were sent into a prison cell. They told us that whatever we were going to say would be futile. All documents were in English, and there was no translator. Some of us wanted to call our families, but they didn't allow us to and spoke to us in a rude manner. Later, we were sent to a prison cell, about 3 persons to a cell. We were told to strip off our clothes and change into prison clothes. Yeah, so this gives us some kind of insight into how the entire deportation process takes place. And with regard to the riot, I believe that there were 53 who were deported, and even the 7 who were actually acquitted, amounting to whose cases were discharged, amounting to an acquittal, were also deported. And as I was reading through the accounts of the 29 who were deported last year, I wonder if the 53 who were deported were also facing the same situation that the 29 did last year. And as Brema has mentioned, the Immigration Act has very arbitrary powers, and so does the Employment of Foreign Manpower Act, because it allows the controller of work passes to revoke a work permit without the right of appeal. And the Immigration Act also allows for deportation, but in the law, anyone who wishes to contest this deportation is actually allowed to appeal to the minister. Yeah, but in the case which I just described, and most certainly in the SMRT cases, the workers were probably not aware that they even could appeal to the minister to contest their deportation. So, and this is the issue of procedural fairness also. Was this informed to the workers? Because procedural fairness means that the administrator is obliged to give a fair opportunity to parties involved in the case to correct or contradict statements prejudicial to their view. And from how the state has responded to the SMRT cases and those who've been deported over the riot, I wonder whether this was indeed the case. Were they told even that they could appeal to the minister against this deportation? So, from a rights-based perspective, if we look at it in terms of access to justice, there are several issues that we need to ask ourselves in relation to due process and deportation. Costs and expediency versus access to justice. This was something which Workfare and Aura had brought up. The absence of an immigration tribunal to handle revocation of work passes and deportations. Whether government officials even inform immigrants that they have the right to appeal to the minister, like I mentioned, and the lack of transparency in reasons for deportation, because under the Act, the minister is not required to explain, because if he considers the explanation against the public interest to do so. I would also like to talk about how the riot's implications in terms of how my fear is that it will enhance further social control mechanisms on migrant workers. Many of us involved in migrant rights activism have always advocated against many of what we think, many policies which we think restrict migrants' rights. And all this is done in the name of security. And some of the issues that we have been chipping against over and over again will be like the security bond. Yeah? All migrant workers who are hired, all employers who hire migrant workers have to guarantee the state a $5,000 security bond. This is in case the migrant worker gets into trouble or he or she is not repatriated. Then the employer stands to lose the security bond if the worker is not controlled. And we've always believed that this security bond violates migrant workers' human rights in many ways. And in light of the riot, would this be further justification for the state to keep policies like the security bond. Another one would be the inability of workers to change employers. Because all low-wage migrant workers who come in are tied to the employer that applied for their permit. So you can't switch employers. And this is a social control mechanism. So would the riot lead to the state thinking that we should not give migrant workers so much mobility in employment? Yeah, because we need to control them further. And there's also the issue of repatriation companies. Yeah, repatriation companies are companies which specialize in sending workers back. Yeah, when employers want to deal with workers that they feel have overstepped the boundary or they are unable to manage, they will hire repatriation companies, and these are guys who will manhandle the workers, lock them up in a room for a few days, and then while the ticket is being purchased for them to be sent back. And during the entire period when they are locked up by the repatriation companies, they may be threatened with things like blacklisting, they will not be able to come back to Singapore again, or they may even be assaulted. And the state so far has not come in to say that the repatriation companies' operations are illegal. Yeah, because it is. Seizing a worker and locking him in a room is wrongful confinement, and I can even, as far as I go and say, it's abduction. But in light of this riot, would the state then say, well, I think these repatriation companies actually serve a good social function in controlling these foreign workers so that they don't run away and cause further problems for Singapore, for the Singaporean public. Yeah, so this is something which we need to, I think we need to think about, and especially activists involved in this work. How are we going to proceed with our advocacy in light of this? And of course, after the riot, we had PMD saying that, oh, we need to build more dorms, we need to ensure that there are adequate recreational and social spaces for them. And what frustrates me about this is that we have been talking about adequate dorms for a very, very long time. Yeah, even before the Serangoon Gardens dormitory debate erupted, the state had already acknowledged that there weren't enough dorms. And 5 years later, we're still talking about whether there are enough dorms. So we need to look at this in terms of, I think, the implications of our immigration policy. Is it sustainable? Because earlier this year, Corbyn once said we need an additional 50 to 80,000 construction workers to build our BTO flats, etc., etc. And of course, the first thing that comes to mind is, where do you want to house them? Yeah, and I believe we do not have enough purpose-built dormitories and decent accommodation for these workers. And I also like to talk about how this riot is going to lead to further policing of migrant workers, especially in the Little India area, where already boundaries have been erected. Boundaries have been what do you call it? These metal barriers have been erected, to prevent workers from going to housing estates. And I have personally seen how the Cisco police, for example, harass these workers when they go too close to the barriers, and they're told very rudely to go away, even when they're just talking on the phone. And some workers have also said that they have experienced harassment from the auxiliary police. So would this lead to further tensions even between the workers and the auxiliary police in the area? Finally, I think I'd like to talk a bit also about the Committee of Inquiry. Moving forward, how should the Committee of Inquiry conduct its proceedings? This is something which folks in Workfare, we have talked and debated, and we have actually come up with some recommendations in terms of what the Committee of Inquiry should do. So I'll just read them out here. First, we feel that the committee should begin the deliberations after the criminal proceedings have been concluded, so as to ensure that there is no conflict of process or evidence, and that the evidence and judgment from the criminal proceedings can form part of the evidence considered by the committee. Secondly, hold all proceedings of the committee in public at a publicly accessible venue and open to members of the public and the local and international media. Appoint an independent assessor under Section 7 of the Inquiry Act who will ensure the independence of the inquiry and that these rules of the committee are adhered to. Fourthly, allow and enable written affidavits by members of the public to be submitted to the committee in evidence. Allow and enable expert witnesses such as the migrant labour activists, migrant worker non-governmental organizations, and academics with specializations in public behavior, rioting, and migrant labour to give evidence either orally or in writing to the committee. Allow evidence based on academic research into crowd behavior, rioting, and other related matters to be allowed into evidence. Allow and enable migrant workers who are present at the scene of the incident, as well as other migrant workers who are acquainted with them, and those who are experienced in the conditions of migrant labour in Singapore, to give evidence orally or in writing to the committee. Allow such affidavits to be collated with the assistance of the migrant worker NGOs or others available to assist the affidavit writers. And lastly, ensure that all evidence presented to the committee be made available to the public on a publicly accessible platform. I think what we want to emphasize also is that there has to be a human rights approach towards how this inquiry is done.